Hi, everybody. We're getting ready to start week 2 of our legal traditions course. This week, we're dealing with a topic that I find interesting and I hope you'll find interesting. Please don't be put off by the title, which is the history of law. We're talking this week about the relationship between law and religion, between law and equity, and between law, morality, and ethics. Yes, the main focus of this course is on ethics, and particularly the ethical codes that govern law enforcement personnel. But in order to understand why professions establish codes of ethics and why it's important to adhere to them, it's perhaps useful to explore the history of our legal traditions in the United States. Most of you know, I assume you know, from civics courses in high school and maybe other courses in college, that our legal traditions in this country are derived mainly from the law of England, from English legal tradition. That's not true in every state. If you are from Louisiana, for instance, your laws historically came from the civil law of France, from the Napoleonic Code. Louisiana has moved away from that in recent years, and it's more likely now to conform with the legal traditions in the rest of the states. Some of the laws in California, New Mexico, Arizona, and Texas also derive from the civil law, not of France, but of Spain, because Spain originally ruled those territories. And Texas, of course, was a republic of its own. We won't get into that. However, for the most part, we in the United States adhere to the same legal principles as those that governed England in the past and still, for the most part, do govern England. And those are separated historically into two factions, law and equity. Matters that fall under the law category were historically dealt with by the king or the queen in England. They were dealt with either directly by the king. The disputes were resolved by appearing before the king and presenting your problem to him and saying, "What can I do about this?" Or, "Will you smite my neighbor for breaking my plow?" Or whatever had happened. The king then, or the queen, would make a decision, and that decision would be carried out. However, there were categories of disputes that the king didn't get involved with that were resolved by the church. In medieval England, before the 16th century, those disputes were resolved by the Roman Catholic Church, which was the church in England. After the reign of Henry VIII in the 16th century, that became the Church of England, for reasons we won't get into here, but you probably know historically. I'd love to get into it. It's so interesting, but no, I'm going to shut up about that. However, let's just say that there were some kinds of disputes that were resolved by the church and not by the crown. And those were chiefly those disputes that dealt with land, or with wills, or with trusts, or with estates, the property one left when one died. These were, I don't know why really, but they historically were matters that the crown allowed the church to deal with. And those disputes were resolved based on principles of fairness and equity. And those categories of cases, therefore, came to be known as equity. And the categories of cases that were resolved by the king came to be known as law, and later as the common law. we still adhere to that common law tradition in the United States. And what it means for us as a practical matter, and let's get practical here and not too esoteric, is that cases that are resolved in the United States are based on cases that have already been resolved in the past. That's what the common law really is. It's a history of a long string of similar cases. How was this dispute between farmer A and rancher B resolved in 1912? Well, is that still a practical way to resolve it? Does it still conform with the present law? If it is, then we'll just use that old case as a precedent, not president, whole different thing. Precedent, Precedent, a precedent for how we're going to resolve it now. That's what the common law is. It is that history of relying on older cases and how they were resolved to teach us how to resolve a present case. Now, what does that have to do with what we're talking about? Why are we talking about these silly old legal traditions? We're not in law school. We don't care about this. What we care about is ethics. Okay, fine. I agree. I'm getting off on a tangent, and I tend to do that, you'll notice. What we need to talk about this week is how these legal traditions have led to not a moral code, because moral codes generally, not always, but generally derive from one's religion. If you are a Jew, for instance, your morality is based on Jewish tradition. If you are Muslim, your morality is based on Islam and the laws of Islam. If you are a Christian, your morality is based on the teachings of Christ and the New Testament. If you are agnostic or atheist, your morality is based on your own observations of right and wrong and your resolution within yourself as to what is right and what is wrong. Fine. That's morality. It really refers to what you believe as a person is right and what is wrong. It doesn't mean that that's how you behave necessarily. If you are a member of a certain profession, despite what your own code of morality might be, you will be governed by the ethical standards of that profession. In other words, ethics, although they may be internal as well, are really imposed on us externally by those people who govern our profession. If you are a doctor, your code of ethics is established by the American Medical Association and by the state medical associations in which you operate. If you're a lawyer, your code of ethics is established by the American Bar Association and by the bars of the various states in which you practice. And you must adhere to those codes of ethics in order to practice. If you don't, then you are subject to disciplinary action by the professional organization that governs your profession. If, for instance, I am a member of the Virginia State Bar. If I treat a client in an unethical manner, then that client is within his or her rights in making a complaint to the Virginia Bar and asking me to be disciplined for ethical violations. Sometimes ethical violations by lawyers or doctors or whomever also are legal violations. An ethical breach is also a crime or a civil wrong of some kind. That's beyond the scope of this week's considerations. We'll get into that later. Those of you who are in this course are more interested in law enforcement professions, not in the law necessarily as a lawyer, or in medicine, or in any of the other professions I've mentioned. Every profession has its own code of ethics. Did you know, and I did not know this till several years ago, hairdressers have a code of ethics. I asked my hairdresser that. She said, yeah, we have a code of ethics that we have to adhere to. I'm not sure how strong it is or how enforceable it is, but it's there. That's not the point. It's there. Law enforcement personnel are governed by the Law Enforcement Code of Ethics, which was established by the International Association of Chiefs of Police. I can't say that very well. You know it probably as the IACP. We will be reading and referring back and forth to the Law Enforcement Code of Ethics and the IACP several times during this course, but you might want to look up the Code of Ethics just for your own edification. It's interesting to read. These ethical requirements, these ethical standards, may or may not agree with your own personal moral code or even with your own personal code of ethics. But what they do is establish standards of your behavior as a law enforcement personnel. If you're going to be a police officer, you must adhere to the Law Enforcement Code of Ethics. Whether you believe in it or not, it doesn't matter. This isn't about belief, it's about behavior. How are you supposed to behave? You saw that in our a discussion topic in week 1. Should a police officer accept a $50 reward for just doing his or her duty? Of course the answer to that is no. You know that. It's a simple answer. The question becomes a little, not more complicated, it's still just as simple, but a little less easy if you increase the stakes. Let's say that this lady who was so pleased with your help had offered you $5 million instead of $50. The answer is still the same. No, you shouldn't accept it. You should just thank her and say, I'm just doing my duty, ma'am. You don't need to reward me. This is my job. It would be a lot harder to do that if the stakes were higher. But an internalized, an externally imposed, but an internalized code of ethics for a profession would automatically give you the correct answer. You would know, without having to think about it too much, how you're supposed to behave in a certain situation. Now, that situation in our week 1 discussion board is a fairly easy one to have to deal with. The dilemma there is not great. You know what you're supposed to do. As we go along, the ethical dilemmas will become a little more complex, a little grayer, not so black and white. And that's where a well-written, easily digested code of ethics really does you a great favor. You know, it gives you a basis for knowing how you're supposed to behave in any given situation. Now, I've gone on for 13 and a half minutes already. That's way too long. I'm going to stop talking. I've written an announcement that kind of already says all this. I do want to say one thing, though, about Milestone 2. You're supposed to answer 4 questions on Milestone 2, and those questions are based on the case scenario that you chose last week in Milestone 1. Make sure this week and every week that before you write your paper, you have read and understood what the grading rubric is asking you to do. I have to grade you on every category in that grading rubric. If you don't address one of those categories, no matter how great the rest of your paper is, that's going to give you a 0 for that category, which is automatically going to decrease your grade. I don't want that to happen. I feel pretty sure you don't want that to happen. I have no choice in the matter. If you don't address a certain category that's covered in the grading rubric, you're going to get a 0 on it, and I don't want that to happen. So please, always before you write your papers, work backwards from the rubric. Look at the rubric first, then start writing your paper so that you know all the categories you have to address. I'm sorry I've gone on so long. I get a little carried away with these topics. I think they're very interesting. Thank you for listening, and see you next week. Bye.